Hi everyone, how are you? I hope you are enjoying this beautiful day. Well, it is for me anyway, over here in Western Australia. So wherever you are, I hope it's also nice for you. I am Jo Elilovich, the owner and director of 3D HR Legal, which is a boutique employment law practice here in Western Australia. And with me, I have Dan Taborski, who's the owner and director of Birchstone Legal, a boutique tax practice here in Western Australia as well. So, as we said in the introduction to this live, we are here today to talk to you about the new JobKeeper scheme and all of the bits of legislation that go with it. So, what we have is a basic statement that all workers who are covered by this scheme are going to be paid $1,500 via a government subsidy. So, that's the starting point, and that's why everyone's so interested in knowing more about it.
So we've got sort of 5 topics we're hoping to go through today, time dependent. So we want to go through first the pros and cons of the JobKeeper scheme and whether it's even worth your while applying for it. Then we'll look through the different eligibility criteria for the scheme. So both for your eligible employees and then for active participants in a business, so your directors, shareholders, trustees and the like. So we'll go through all the legal stuff, the legislation, explain all that, and then we'll come back to the practical steps, what you need to be doing now if you want to claim the JobKeeper payments. And then Jo will finish off with going through some of the new JobKeeper directions that employers can use if they're eligible for the scheme.
Mm-hmm. So because there's so much, we're going to get cracking into it. Please post your comments or ask your questions on this live, and we will either try to answer them as we go along. Given there's 2 of us, we can sort of keep track of the comments and questions, or we'll come back at the very end and make sure that we've covered everyone's questions. Of course, if you're listening to this as a replay, feel free to still leave your questions and just tag either Dan or I, and we'll come back and answer it for you when we get to it. So starting off, the pros and cons. It might seem strange to think about it, but it is definitely not the case that just because you're eligible, you will want to use this scheme. You need to consider or not whether the scheme actually works for you and for your business. So generally speaking, rule of thumb would be if your employees are currently working and you have found that you're paying them that $1,500 per fortnight already, then the scheme is going to be valuable for you, because effectively that $1,500 worth of wages is now going to be paid by the government. But what if your employees aren't working, or what if they're working and the pay rate that they're earning is less than that $1,500 per fortnight? Is it still worth your while to enter into this scheme? And this is where you need to weigh up some pros and cons. On the pro side, as the Prime Minister has been telling us, this method is a way to maintain the employment relationship. So as your business is in sort of hibernation mode, as it has been described, you are still ready to go when things return to normal, or some more semblance of normal that we're used to. And your employees are there. You've got the trained bodies ready to help you out. It's also the fact that this is your opportunity to be a great employer, because for a lot of people, what they can earn under the JobKeeper scheme is going to be a lot more than they would get under JobSeeker or some other kind of government assistance. So, if you can take on that admin burden, you can be seen to be doing a great thing by your employees, and you're going to cement that employment relationship. It's also an opportunity. Yeah, Dan?
Jo, I was going to say one of the big questions that I've that's been asked to me over the past week is if we participate in the scheme, does it mean that all our employees that are eligible need to be in it, or can we pick and choose which ones we want to receive the JobKeeper payment? And unhelpfully, we've had some sort of contradictory messages from probably the explanatory statement that was issued with the rules for the JobKeeper statement. It sort of referred to one of the key features of the scheme is this one in, all in. So if the employer decides to participate in the scheme, so it's optional whether you participate, but once you participate, then all your employees are in. There's been some commentators that have said that, well, the way the rules have actually been drafted doesn't actually reflect that, and there is actually a choice of the employer which employers they want to nominate. Yesterday afternoon, we saw some guidance released from the ATO And some of the wording, the guidance doesn't quite explicitly address that question, but some of the guidance is probably creates more confusion that it's actually assisted taxpayers with. So it uses the phrase, for example, you need to identify which employees you intend to claim the JobKeeper payment for. Whereas I think the way the explanatory statement was drafted is that there's really no choice. Once you're in, any employees that are eligible are also in. So that's going to have a large impact on whether people decide whether they want to participate or not. They may well be happy to participate for some of their employees, but if they have to do it for all of them, then that brings with it additional risk, additional cash flow requirements, which may tip them over to the edge of deciding, no, we don't want to participate in this scheme.
Yeah, and it's really frustrating that we can't actually give an answer right now because, we are in this situation where, as you said, the explanatory memorandum says you must do it for everyone, and yet the rules and the law doesn't seem to reflect that. So unfortunately, we're on the lookout right now for clarity on that, as are a lot of other people. And when we know more, if more comes out, then we will definitely update everyone and let them know on that. So that is definitely, a factor that falls into this, weighing up the pros and the cons. And I think the big cons for people to consider around this scheme are, one, the fact that whilst someone is on this JobKeeper scheme, they are continuing to accrue entitlements. So if they are completely stood down without pay, they're not working at all, whatever they would normally accrue by way of entitlements, so part-timer or a full-timer, perhaps they're accruing somewhere between 10 or normally working between 10 and 38 hours a week, they would be accruing leave entitlements based on those numbers of hours, even though they're not working at all. Obviously, casuals won't be accruing anything, so that's a little bit easier and you don't have to worry about that so much. But for those permanent part-time and full-time employees, you do have to consider the fact that they are continuing to accrue entitlements whilst they're on JobKeeper. So you're accruing liabilities, even though there's no perhaps income coming into your business, or the income isn't where you would want it to be to manage those liabilities. There's also the fact that it's to me, who's not a tax lawyer, just an employment lawyer, the tax system is a nightmare, and these laws are not easy to deal with. And I'm finding already, we've just discussed, it's not clear whether it's an all-in or not all-in. So how is the average business owner going to make sure that they're compliant with all of these rules and regulations to do the right thing? Because as we know, nobody wants to annoy the tax department, because they are very well resourced and they're very happy to come back and tell you, hey, you've done something wrong and we want you to pay back money. And by the way, here's some penalties. So you need to be prepared to take on those risks and be confident about what you're doing, and happy that you have the resources to pay for the right advice or spend the time that's needed to make sure that you do it correctly.
We've had a few questions come, Joe. We will get to them. We'll get to them when we get through the relevant parts of the eligibility criteria. So
Good
I
idea.
think Sarah and Michelle, we will get to your queries.
Okay, so what we have done there is give you some things to think about with the pros and the cons. So you have to decide, is this system one that is suitable for you right now? And if it is, if you think, yeah, this is okay, I still see some value in this. It may be that your employees have been stood down, but you can get them to do different duties and you can have those duties paid for using the JobKeeper scheme. And there's definitely some financial value in looking at it. So let's talk about eligibility. Who is an eligible employer, Dan?
Yeah, so I guess just at the outset, there's sort of two different schemes within the one scheme. One is for your employees, and the other is actually for active participants in the business who may not be employees. So like working shareholders or directors or trustee beneficiaries that aren't themselves employees of the business but still have an active role in there. So we'll first deal with the employees, and then we'll come back to those active business participants.
Yep.
So as we go through these rules, you'll see there's a number of requirements, and some need to be met each fortnight. The JobKeeper scheme is done on a fortnightly basis. And some need to be met just once at any time in the period, or some need to be met at 1 March. So just when we go through the criteria, we'll explain that, but it is quite tricky, and it is something you have to work through quite methodically to make sure you qualify for. So
tick all the boxes.
Tick all the boxes, exactly. So the first requirement is for an eligible employer, on 1 March, you had to be carrying on a business, okay, or a not-for-profit pursuing their objects in Australia. So that's a 1 March requirement. Doesn't apply for new entities set up since then. Then the key requirement for employees is this turnover decline. So we need to have, for most businesses, it's going to have to be a 30%. If your turnover is over $1 billion, it's 50% decline, or if you're an ACNC registered charity, it's generally 15%. But for most people, it'll be 30%. So the way you do that is you have to look at a period, and so the period specified in the rules is either the month, either a month between March and September inclusive, or the June or September quarters. Now, people have asked, well, does that have to match whatever? If I'm eligible, my BAS returns on a quarterly basis, do I have to choose a quarter? The answer to that is no. You have the freedom to choose whether you want to do a month or quarter. Entirely, legislation gives you the choice. If we're looking, I guess practically, if we're looking for this first JobKeeper fortnight, which has just passed, so that was from 30 March to 12 April. There's 3 different periods you can test. You can either test the month of March, the month of April, or the June quarter. And if you satisfy the decline of turnover test for either of those periods, you qualify.
How are you testing the June quarter? Are you predicting?
Exactly. So some of this is depending on when you're testing. So if you're doing the March month, okay, March is already finished, so you can actually base it on actuals. But if you're doing the June quarter, that has to be a forecast. And so that brings with it, like, how do you forecast? John, I don't know for myself, how do I know how much I'm going to bill? The June quarter. I mean, it's very hard at the best of times, but even in the current situation, in particular, it's going to be very hard to estimate.
And then you potentially run into that situation where someone's forecast and then they're actually doing everything that they can to make sure that business shows a 30% decline, which is, not going to pass the integrity test of the scheme.
Exactly, yeah. So as Joe said, there is also anti-avoidance provisions that will capture if you arrange your affairs in a way to qualify. We should say, if you do forecast now for June and you think you will have a 30% decline, but when you get to the end of June, you only experience like a 28% decline. That doesn't mean that you're automatically eligible. As long as your estimate at the time when you made it was reasonable and you can support that. So there's going to be an obligation to have records and sort of documentation to support that your estimate was reasonable. But if it was reasonable back at the start of like this week in April, you're still eligible. And the fact your circumstances might change, your turnover might increase, your decline might not be as large as you forecast, that won't make you ineligible for the requirement in that period or even going forward.
So that means that if you've got some really good paperwork, really good projections, you've worked with your accountant or your bookkeeper or whoever it is, or your tax lawyer to show that I'm going to have a 30% decline, and then you don't, it's okay. You're still going to be able to keep that money.
That's okay. But you're going to have to expect the ATO, it's going to flag in the ATO system. The ATO is going to be probably sometime down the track. Please explain what happens. If you can explain.
So there's a question. There's a question that's just been asked. If your predictions are wrong, do you have to pay it back? And we've just described one scenario where your prediction is wrong and you won't have to pay it back. But if you don't, so I'm assuming that if you don't have that good evidence supporting you, then you will have to pay it back.
Yeah. It's going to be all around being able to substantiate that what you estimated was in fact reasonable.
Yeah. So it does, but just to be clear, someone asked another question here. Do you have to pay it back if your projections are incorrect? So it's not about getting to the end of June and looking at the actuals. It's all about whether your projections were reasonable at the time, even if your actuals end up pushing you under the 30%.
And I should say it's going to be more. I think it's going to be more than saying, look, this coronavirus situation, we think it's going to have a negative impact on our business. Therefore, we're going to predict it's going to be more than 30%. You're going to need something more than that. You're going to have to show, look, these are the amount of inquiries we've had come in. It's dropped down substantially from prior periods. This is the number of bookings we've had. It's declined. There's going to have to be something that you can point to saying, this is why we thought it's going to drop by this percent.
So if people want to be on the safe side, then the idea is to wait till you've got some actuals and don't claim the scheme or claim under the scheme until you've got those actuals, because then you're not at risk of paying it back.
That's right. The downside of that is you miss out on some periods that you won't be able to claim it for, but you've got for some businesses it'll be obvious. They've stood down on the staff. They're not generating any income. They're clearly going to satisfy. But if you're going to be on the borderline, then you have to think hard about whether you're prepared to make a prediction or whether you actually want to wait until you've had a completed period.
Okay. One of the questions that comes up in this is this idea of whether or not you need to be qualifying for every single period.
So the question is, well, if we meet the turnover in March and in April, and then we don't meet it in May, does that mean we're no longer eligible? And the answer to that is a clear no. Once you've met the turnover at any stage, from then on forward, you're eligible, and there's no need to retest. The ATO will still ask for information about your turnover, and I think that's more for just their record keeping to see how the economy is going, but that won't affect your eligibility per se.
Okay, great.
Now,
there's a whole heap of.
So you there, Joe?
Yep, I'm here.
Yeah.
You got me?
Another question that's come up quite a bit is, well, when you're calculating your turnover, do you have to use the same basis of recording as you do in your BAS? So if you do your BAS on a cash basis, do you have to calculate your turnover on a cash basis? And the ATO hasn't been explicitly clear on this yet, but my view is, I'm reading the rules, that there really is no choice. You don't have a choice. The rules prescribe how it has to be done, and it's based on suppliers made in a particular period. So that's not really a cash basis. That is more closely aligned to an accruals basis. So that may have impacts on some. For example, some accountants, they might be very busy in billing through this period, but may not be recovering. Then it seems like it's going to be based on the amount you've actually billed, not actually recovered. So an accruals rather than a cash basis. So that will be important for some businesses.
There's a couple of questions. One is around service entities, and I know you and I were discussing that yesterday.
Yeah.
And the impact on them. So do you want to touch on that quickly?
Yeah, let's do that. So under this base turnover test, it's pretty clear, unless a service entity which really just employs staff and then probably charges a markup to the practice entity based on the number of staff, unless they get rid of staff, their turnover is not going to decrease. So based on the rules that are prescribed in the rules, you're not going to qualify. But the rules do provide that the commissioner, so the ATO, can provide alternative tests where there's no appropriate comparison period. Now, so there's a possibility that the commissioner may make a particular alternative test that could be used there. And in fact, that's what would need to happen in that case if you're going to be able to qualify. Either there have to be a new test inserted, either through amendments to the rules or through the commissioner exercising his discretion. Some people have raised, well, can he actually even exercise his discretion in that case? Because there is actually a relevant comparison period. So we don't know yet. The fact is, at the moment, we just don't know, and we will hopefully know within the next couple of weeks. But there'll need to be either an alternative test or a change to the rules, because at the moment the test that's provided for you can't satisfy unless you got rid of staff, which is kind of contrary to the purpose of the scheme. Absolutely. I think there's another question, that deals with a similar question, or it doesn't fall within the rules.
So this one, they acquired an office back in July, and a second office. Their turnover, therefore, this year in the turnover is higher this year than in March, April 2019 because of the two locations, but they expect it to drop away in May because of the lag between when work comes in and when they get paid. So it looks like they won't be eligible. So is this one of those situations where there might be some discretion?
Yeah, and indeed the commissioner has. It's been highlighted. There's been a few situations which have been highlighted in the explanatory statement to the rules where they're expecting the commissioner will issue an alternative test. This is one of them where there's been like an acquisition partway through or since within the last year that has increased their turnover. The other situations I've sort of highlighted are, well, for startup entities that have been went in existence a year ago. Obviously, you haven't got a comparison period there. What are you going to do? Essentially, kind of we'll average the turnover for the periods up to when you apply the test, since the entity has been in existence. And if your turnover has declined 30% since then, you will have met the test. But that's only comments in the explanatory statement. The commissioner, the ATO, still has to come out and make the alternative test, and it may be the same or may be different to what they've expressed in the explanatory statement.
So again, for those people, they're probably best off to wait till those tests so they can find out about eligibility rather than making any kind of $1,500 payments now that they might just never see again.
Exactly. You're going to have to wait, and we'll come back to when we talk about when these amounts have to be paid. That there will be some leeway for the first month.
Yeah.
So
okay. Great.
You can wait.
So what about eligible employees? We've talked about who is an eligible employer, and we've got these 1 March requirements and the decline in turnover test requirement. But who would be an eligible employee for those employers?
And again, similarly, there's 1 March requirement. So the 1 March requirements for employees is that on 1 March they have to be employed by the entity, either full-time, part-time, or a long-term casual. So, Joe, you probably can speak more about what a long-term casual is than I can. Do you want to just address that now?
Yeah. So with the casuals, obviously you've got those people who are, doing a few hours here and there each week or fortnight or month, and there's a very much a randomness to it. But where you've got some regularity and systemization to how often those casuals are working for you, then they're becoming more what they call a regular casual. And there is also a requirement that casual has been employed by the entity for at least 12 months. So just because they meet the 12-month requirement doesn't mean they're going to meet the regular and systematic requirement. And that's where some people will fall down, because they'll just assume, well, these casuals have been with me for over 12 months, so they must be covered. But if they've only worked here and there, and there's no consistency and everything, then they won't meet that long-term regular requirement.
And particularly where you've had someone may have acquired the business within the last year, there's rules that deal with that. But how are you to know how they've been employed for that entire 12 months?
Yeah, absolutely.
We'll get to there is an obligation on the employee to provide the employer with notice that they meet those requirements. But but ultimately the employer is still going to be liable if they get it wrong. So the employer is going to want to do some due diligence there to make sure all their employees qualify. So 1 March requirements must be employed. They have to be at least 16 years old. They have to be a resident, and they either need to be a citizen of Australia, a permanent visa holder, or a holder of a subclass 444 visa, which are New Zealand citizens. So they are your 1 March requirements. They just need to be satisfied once, obviously. There's then each fortnight, the employee has to continue to be employed. So if they're not employed, not going to get the payment. But if they are employed for at least 1 day of that period, you qualify. And that includes employees that have been stood down, or employees that were made redundant and have since been rehired. Practically, Joe, rehiring employees, how would you do that? Like, what would you do with the redundancy pay? Would you make them claim them back?
It's such an interesting one. I think that if you've made a decision to terminate someone's employment after the 1st of March, because obviously it has to have occurred after the 1st of March, think long and hard before you just decide to rehire them. Can consider whether or not it is worth your while, whether you need that employee, and so on. If you have done it by way of a redundancy, which more than likely it was. Obviously, for casuals, the redundancy situation is not relevant because they're not entitled to redundancy. But if it's been a permanent full or part-time employee and there was a redundancy involved, then possibly you had to pay a redundancy payment, although small businesses typically don't pay redundancy pay. And in that case, then you need to think about, well, am I going to be making an arrangement with the employee to pay that redundancy back? How does that impact on the tax declarations and withholdings that have been made? Are you asking for the employee to pay that money back to you? How are you going to arrange it? And also, if you're getting them to pay it back, then you will need to usually reinstate all of their leave entitlements. So their leave entitlements for annual leave, for long service leave, sick leave, everything else. It may be cleaner for you to just say that employment ended and they're now re-employed, starting fresh.
It does sound very messy, Jo.
Yeah, messy.
Okay, so they have to be employed during the fortnight. The employee
Yes.
must agree to be nominated and provide a nomination notice to the employer. So the reason that mechanism is in there is because if an employee is employed by more than one employer, they can choose who they want to receive the JobKeeper payment from. And so there needs to be a notice from the employee to the employer saying, I agree for you, this employer, to include me in your JobKeeper scheme. And the ATO yesterday released a form on their website where you can do that. And so when we come down to practical steps on what you should do, one of those key practical steps is you've got to start getting those forms signed out and signed for employees you want to nominate, because that may be easier said than done to actually get the forms back from some of your employees if you've got a large number of employees. There's some exclusions. So if you've received paid parental leave, the government version, dad or partner pay, or if you're receiving workers' compensation and you're totally incapacitated for work, you can't receive the JobKeeper payment on the basis that you're receiving some sort of other funds through either the government benefits or for workers' compensation.
Yeah, I think it's important to note what you just said then, that when it comes to parental leave, it's the government version that they're talking about here.
Yeah.
So if you're currently receiving paid parental leave from your employer under an employer scheme, that doesn't stop you from being an eligible employee for the $1,500. Equally, it's important to note that if you're just on unpaid parental leave, so you're still connected and involved and employed by the business, but you're just on unpaid leave and not receiving any payment from anywhere, you are entitled to the JobKeeper as well.
Great. And then we get to this, what's called the wage condition. So there's a requirement that employers must pay employees at least $1,500 per fortnight before tax. So if we just sort of step through the different permutations there, you can have an employee that's getting more than $1,500 per fortnight. So they just continue to get paid the way they are, and the employee gets a subsidy which just comes with their cost of employing that employee. So that's relatively straightforward. But where you had an employee that may be earning less than $1,500, so they may be part-time or casual and only receiving, say, $1,000 a fortnight, the obligation is to still pay them $1,000, but there's also an obligation to top their pay up to $1,500, so an extra $500 top-up pay to be able to qualify for the JobKeeper scheme. And then with stood down employees, of course, are really receiving nothing. So there's an obligation to pass an entire $1,500 onto them. So that then brings up questions. Well, what about superannuation? Do I need to pay super on these amounts? And the answer, and there needs to be amendments made to the superannuation legislation to cover this, but this is what we're told is the way it's going to operate. That if they're working, they're paying them for the hours they're working, so your full-time employee that's earning more than $1,500, continue to pay super. Your part-time employee or casual employee that's earning less than $1,500, you have to pay them on the portion they're working. So if they're ordinarily earning $1,000 per fortnight, you'll pay the super on that $1,000, but the $500, the additional top-up amount, won't be subject to super guarantee. And for the stood down employees, that entire amount that you're paying, the top-up payment, the $1,500, there won't be a super guarantee obligation on that. We then have payroll tax. Well, do you have to pay payroll tax? If you're in the payroll tax scheme, do you have to pay payroll tax on that? A lot of employees, most state governments, WA inclusive, has issued some pretty generous payroll exemptions and deferrals and rebates. So you may not be paying payroll tax anyway. But if you are, then there probably needs to be legislation in each state to actually carve these top-out payments out of payroll tax. So far, we've had South Australia and Western Australia come up and say, we're going to make these not subject to payroll tax.
Good to know we're ahead of the curve sometimes.
Sorry, Jo?
Good to know that WA is ahead of the curve sometimes.
Yes. We don't know if that payroll tax is going to be just a top-up amount I suspect it's just the top up amount that's going to be exempt from payroll tax, and not the entire amount. If it's just a subsidy for what they're ordinarily getting paid. And again, workers' comp as well. It's another issue that we don't really have any clarity on. Are you going to have to pay workers' comp on these amounts as well?
Yes.
All questions which we don't necessarily have answers for at the moment.
Yeah. So before we get into eligible business participants, I just wanted to hit this question of my workers are stood down, and if I have to pay them the $1,500 to meet the wage condition, I don't have the $1,500 to pay them. So it may be like if you're unsure about your eligibility, then definitely don't do it. Is my view. That if you're reasonably confident that you're going to meet that eligibility requirement to get the $1,500 subsidy, but you just don't have the money to pay them now so that you can reclaim it from the government, where do they go?
But Joe, the government has just said just go to the bank. The bank will be happy to hand you out money to fund your cash roll, which I think is probably easier said than done to be able to get. So I guess we should talk about when these amounts have to be paid. Ordinarily, they have to be paid in the fortnight that they relate to. So you can't wait until May. So for the periods in April, we can't wait until May to get the money from the government and then pay our employees. You have to actually pay them in the fortnight. For the first month in April, the government has said, look, because the rules have just come in, we will allow you to pay them by the end of April. So if you pay these first 2 fortnights by the end of April, we'll consider it as if it had been paid in the relevant periods. But that is probably only just going to be for April, and it's still going to be before you get the money back from the ATO. You're not going to get the money back from the ATO until probably the first week, maybe not until up to the 14th of May. So there will be a period of time when you have to fund your payroll. One of the ideas I've had has sort of been suggested to me, Joe, which is probably, well, I'll get your thoughts on it. But people have said, well, can we get our the government said, let's get the banks to lend the money to us. Can we ask our employees to lend the money back to us? So we pay them and they lend the money back to us until we get the money from the government. What are your thoughts on that, Joe?
One, the employee may not have the money to loan to you in the first place. So there is that issue. But I know that from a bookkeeping perspective, there's this idea that there is no money that changes hands. There is a provision in the Fair Work Act, if that applies to you, which is, most people across Australia, that says that you can't make deductions from an employee's salary or entitlements other than where the deduction is, one, agreed to in writing by the employee, which they perhaps would in this case, but more importantly, they can only make deductions where it is for the benefit of the employee. So you would have to be making it really clear that this deduction is for the benefit of the employee. And I suppose you can argue that making this deduction from their salary in order to pay them back salary is to their benefit, because otherwise the business is not in a position to be able to pay this $1,500 and therefore seek it back from the government. But it is something that I would tread very carefully on if anyone is inclined to look at this idea. And I would want to make sure that you've got some really tight agreements. Everything does have to be in writing, but I would be wanting to make sure that as a loan agreement, you've actually got a loan agreement drawn up, and that there's real clarity around who's paying who and when those amounts kind of are called in and that kind of thing. And maybe the employee is even going to want some surety around their employment length. To go through this process as well.
Yeah. Joe, we've had some questions come through. I'll try and address some of them now. Some of them are, how do we actually show this on your pay slip? And I think it's generally going to be, I think most people are sort of doing it as a separate maybe allowance that goes through separate from your ordinary pay. So you just isolate the top-up amount.
Yes.
Do we know how to top up employees to $1,500 for periods we've already paid? And again, as I said, we've got up to the end of April to be able to make that payment. So if they're earning less than $1,500, as long as you make that additional payment before April, you should be okay.
Yep.
And so just to confirm, if your employee was earning more than $1,500 a fortnight, you have to top up to that amount, or if the business can't afford to do that, can we just pay $1,500 and maybe reduce their hours? Joe, do you want to deal with that? Because that's kind of, I mean, it probably depends whether they're working or not, or they've been stood down, and then sort of ties into new JobKeeper directions.
Yeah, absolutely. So you can definitely make agreements with your employees around reducing hours, and there's a lot of discussion around that. And some of the new JobKeeper directions actually enable you to make a direction to reduce hours, but you can still have the ability to just agree things as well. And again, as we said at the end of this live, which is clearly going longer than the half hour we thought, we will get to the JobKeeper directions. So with that question, basically what it is that you can, so long as you're paying that $1,500, then they will be entitled to receive that $1,500 subsidy. You don't have to keep paying them their normal fortnightly wage if that was more than $1,500, if you've made other agreements or directions.
Great. Look, in the interest of time, I might move on to eligible business participants. So
absolutely. Yep.
We've dealt with employees. Now we're talking about business participants. So these are your sole traders that don't have employees, your partnerships. So your partners can't be employed by the partnership. They don't receive a salary, so they can't be eligible under the employee head. Your working directors and shareholders and beneficiaries of trusts. So these, when the cash flow boost came out, a lot of these people missed out. So the cash flow boost was a payment up to $100,000 based on your pay-as-you-go withholding. Because these people didn't get paid salaries or wages, there was no pay-as-you-go withholding, so you couldn't qualify. So the government has tried to, in this scheme, have the second head of the JobKeeper payment for these people that have missed out under the JobKeeper, under the cash flow boost. So again, there's a requirement for the entity and there's a requirement for the actual participant. So the first, we look at the entity requirements. The first is that they have to be a for-profit entity, can't be not-for-profits. Again, on 1 March, they had to be carrying on a business. And there's an additional active requirement. So they had to hold an ABN by 12 March and had to have assessable income in either the 2019 tax return income year or had made a GST supply broadly between 1 July 18 and March 2020. And have provided the ATO with a notice of that. So provided them with a tax return or a BAS statement. So it's an active requirement. It's actually very complex, and there's some entities that may not, like if you were only set up in the 19 financial year, chances are you may not have lodged your tax return yet, because it probably isn't due until May 2020. So you may not have met that requirement, and you may not be registered for GST, so you haven't done a GST return. So there's discretion there for the Commission to apply an extra period of time for you to providing with notice of your tax return or your activity statement. But that's something you got, if you fall within that category, it's something you have to look quite closely at. So that's an additional requirement that's not present for employers. The declining turnover test is essentially the same as what we talked about for employers, so we won't go through that again. And there were some exclusions that apply for both employers and eligible business participants, like banks, government entities, and companies in liquidation. They apply for both. So if you're one of those entities, you can't get the JobKeeper scheme. Okay, so that's the entity requirements.
Just quickly, Dan, you mentioned at the beginning the cash flow boost. Is this a either or option? Like if someone gets cash flow boost, can they still pursue the business participant option as well?
No, they're entirely separate. So you can absolutely claim both. Some businesses that don't experience declining turnover will be able to claim the cash flow boost because that hasn't got the declining turnover requirements. So I think you'll find more people qualify for the cash flow boost that will qualify for this. The exception being these business participants that miss out on the cash flow boost.
Yeah. All right. So who's a eligible business participant as an individual?
So they can't be an employee of the entity because they would receive something under the employee head. Nor can they be an employee of any other entity other than the casual. And I think the rationale behind that is if you're an employee of another business, then you should be claiming JobKeeper through that business. But that may create some unusual situations where, for example, if you've got an Uber driver who spends most of his time driving Ubers and may work part-time 1 day a week at Woolworths or something, night filling 1 day a week. If he's a permanent part-time, he won't be able to claim JobKeeper through his business, and he may well, Woolworths, your big supermarkets probably aren't going to have the decline in turnover, so may not get anything for either of them. So there will be some people that miss out here. So you can't be an employee of another entity. They must be actively engaged in the business during the fortnight and at 1 March. So that's it's unclear exactly what that means. We expect we'll see some guidance from the ATO on that, but essentially they need to be working in the business. And then they have to have one of the following roles. So if it's a sole trader, it can be the sole trader.
Yep.
If it's a partnership, it can be one of the partners. Now, the important thing here is that it's only for one eligible business participant per entity. So even if you have a partnership of unrelated parties, so maybe builders that have come together, only one of the partners can get the JobKeeper, not both. Then you've got directors and shareholders of companies. Again, only one of those can qualify. And for trust, you can include one adult beneficiary. And even then, for trust, there are some situations where you might not qualify. And I might just try sharing my screen if I can, just to show an example of one which won't qualify.
Yep.
So can we see that? Yeah, I think
it's loading. Here it comes. Yep.
So in this case, if you've got the unit trust here carrying on the business, and its units are owned by a discretionary trust, and then the discretionary trust has adult beneficiaries. In this case, the unit trust won't qualify for the JobKeeper scheme because it has no adult beneficiaries. And similarly, the discretionary trust won't qualify because it's not carrying a business. So I've been speaking to some people yesterday who had a structure like this, and unfortunately, they're just going to miss out. Even though their turnover is basically going out to nothing, the way the rules have been drafted, they're just going to miss out, and that's absent some change to the rules is just going to be too bad, unfortunately.
Okay.
There's some other 1 March requirements for the eligible business participant. They have to be basically in the role and actively engaged in the business at 1 March. They have to be 16 years old, a resident and a citizen, or one of the visa holders that we spoke about before.
Yes.
And the same exclusions around government parental leave, workers' comp, etc. Importantly, one difference between this head, so the eligible business participant head, and the employee head, is that there is no wage condition. So there's no obligation to pay them the $1,500 a fortnight. They're going to qualify regardless. So that's
someone who's been taking the question here. If I'm a business owner and a partnership and I've just been taking drawings, then so long as you're only claiming for one partner, you're going to be able to qualify. And of course, you meet all the other tests.
Yes, absolutely. Yep.
Cool. All right. So I don't think there's any questions in here that you can have a browse through, Dan, while I'm talking, but I don't think there's any other questions here that we haven't answered around eligibility. We can always come back to it at the end as well.
There was a question about drawings, but I think we've dealt with that.
What we just covered. Yep. So that leaves us with some practical things to wrap up this section of eligibility. And we've kind of listed about 10 different things that we think you should do. And we'll probably prepare a list of this and post it somewhere so you don't feel you need to frantically write any notes. The first thing is make that decision around whether or not you want to participate. So you've now heard some pros and cons about it, and you've also heard the complexity of the scheme. So make that decision. Is this something that you're interested in? If you do want to, then go on the ATO website and register for updates. Maybe even do that even if you're not sure 100% yet whether you want to or not. Then go through the questions around, am I eligible, and are my employees eligible, or is my business participant eligible? Dan and I are going to be working together to create a bit of a quiz around this. Hopefully it'll come off. And that means that you'll be able to sort of, answer the questions and tick those boxes that we were talking about. If you're not going to participate, whether you're eligible or not, it's a good idea to let your employees know, because otherwise you're probably going to be fielding lots of different questions. So just send them a letter and just say either I'm not eligible or I'm not participating, whatever language it is that you want to use, but just be really clear. You might even tell them I'm not doing it at this time, but I might reconsider down the track.
And you're probably going to have some pretty unhappy employees if they think they're going to be eligible and you're saying we're not prepared to participate. So you're going to have some way to deal with that.
Yeah, absolutely. If you are going to, or you're keen to explore it further, then send the nomination form to your employees. The ATO have issued the employee nomination form. It is up on their website, and we'll post a link to it as well. And that just basically asks them to confirm that they meet all those eligibility requirements that we were talking about. Then you need to make sure you collect them, of course, follow everybody up, and you will have the opportunity to enroll in the scheme from the 20th of April. So the ATO have told us that by 5 days' time, they will be ready to go and they will have their tech sorted out and we can all enroll and probably crash their system. So, you can either do it through your business portal or through a tax agent. So there's a couple, you don't have to, try and figure too much out yourself if you don't want to. Then you need to make sure that you have paid those eligible employees the $1,500. You've met that wage condition if you are intending to claim for the month of April, and of course, after that time as well. As Dan said, it's really important to have records and be able to substantiate your eligibility. So make sure you've got that. It might be worth, I would suggest it's strongly worth getting some advice from a tax lawyer, accountant, BAS agent, something like that around these eligibility requirements. And then, of course, from the 4th of April, you can actually apply to get that JobKeeper payment back in your hands. Well, not back in your hands, but in your hands. Have I missed anything?
I think that's for the immediate stuff, I think that's what people need to be focusing on. There'll be more. The ATO will come up with more guidance, and there'll be records the ATO will require you to provide them around employees and all that sort of thing. That'll become clearer as more guidance is released on the ATO website.
Yeah. Okay. So to take us to the end of this live, I'm going to touch on the JobKeeper directions that have now been created in the Fair Work Act. So what we have is, prior to now, we had one stand down clause in the Fair Work Act, which enabled you to stand down where there was a stoppage of work, where the employer could not reasonably be held to be responsible. So, for example, the government made an order that all movie theatres must shut. Clearly, if you were running a movie theatre, you had no other option but to close the business, and that would have an impact on the majority of your employees, if not all of them. There was also, of course, the ability, as there always is, to agree things with your employees. So you can negotiate changes to contracts and wages and hours of work and those kinds of things, so long, of course, as you're meeting all of the minimum government legislative requirements, such as minimum hourly rates of pay. What has been done in conjunction with these JobKeeper payments is that they have introduced a whole new raft of directions that an employer can issue to employees. And there's also a couple of requests that an employer can make as well. So there are five different directions now under these JobKeeper enabling provisions. 3 of them are around standing down. The first one is standing down so that an employee you're telling them that they're stood down, that they don't work on a particular day or days. The second one is that you're asking them to work a lesser amount on a day, so that's shorter shifts. The third one is that you're reducing their overall hours in any given week. So they're the 3 stand down directions.
Joe, can I ask him, can I reduce their hourly rate? Am I allowed to do that?
Not under the not under these JobKeeper enabling directions. Definitely not. Yeah. So the conditions to be able to issue one of these 3 stand down directions are, because we love to have tick boxes, the employee can't be usefully employed. So you can't just say to them, I want you to stay home, or I want you to work 20 hours instead of 38 hours, if there is useful work for that employee to do. And the requirement is that they can't be usefully employed due to the pandemic or due to government initiatives to slow that pandemic. So it may be that they can't be usefully employed because of just a general downturn in your business that was going to happen regardless of the coronavirus and everything that's come about. And if that's the case, you won't be able to rely on these stand down provisions. You have to make sure the direction is safe. It must be reasonable. We just love using the expression reasonable in law. And you must also have consulted with the employee around it. So at the very minimum, that requires giving a 3-day notice period, which you can actually agree to shorten if the employee agrees to shorten it. The direction needs to be in writing. And as Dan pointed out, you can't reduce the hourly rate when you are doing a stand down direction. The thing to look out for if you are thinking about stand down directions, leave still accrues as normal. So, as I said, if you've got that person who is full-time and works 38 hours a week and you've asked them to stand down for half of the week and you only want them to work 20 hours, they're still going to accrue 38 hours worth of leave accruals for sick leave, annual leave, long service, etc. Also, while they're on stand down, an employee can make a request for training or professional development, and you, the employer, can't unreasonably refuse it. So if you've stood down your employees completely, you perhaps have no work for them to do at all, they could make an application and say, hey, you know what, while I'm stood down and I'm not doing anything else, can you give me some training and some professional development? And you, the employer, need to consider that request, and you can't unreasonably refuse it. So obviously, if it's really expensive, that would probably be a good ground for reasonably refusing it. But if it's a cheap thing, or perhaps it's just about your time or them coming in and doing some development with someone else who's still working so that they can upskill themselves, then that would probably be a reasonable request that you might not be able to refuse. The other 2 directions that you can make are around changing duties or changing location of work. So it might be that you have an employee who's the duties that they normally perform, they're just not there, or you don't need them for the same amount that you normally would. So you might look at moving them somewhere else and to perform some other duties. The one that I've heard a lot about is getting some of their workers to do, for example, manuals or processes and procedures in the workplace, things that you don't normally have time for when business is as usual. And another one is things like marketing. So social media posts or writing blogs or creating videos like these, something that is going to, support your business, keep it front of mind and keep it active. They're the kinds of things that I've heard so far people are using to redirect their skilled labor into performing other duties. Again, if you want to do either of these directions, the direction has to be in writing. It has to be safe. If it is changing duties, you have to make sure that the employee has the necessary licenses or qualifications to perform those duties. It's got to be reasonable. You've got to have some kind of consultation around it. And in the case of changing duties, this is a clincher. You have to make sure that you as the employer have information that causes you to reasonably believe that the direction is necessary to continue the employment of one or more employees. So if it's not necessary to keep that person employed or to keep other people employed, to have someone writing blog posts or creating procedures, then arguably you might not be able to get them to change duties in that way. All of these require the wage guarantee to be met as well. So there are 5 directions, as I said. So they are directions that you can make so long as you comply, then there are also 2 requests. And that is, one, to change the days or hours of work that an employee is performing. So this isn't talking about reducing the number of hours that they perform over the course of a week. It's just changing it up. So perhaps they normally perform their work on a Monday and you're asking them to do it on a Thursday to link in with somebody else. Or it might be that you are wanting them to take annual leave. So you put in a request and ask them to take annual leave. And that could include agreeing with the employee to take twice as much leave, so a longer period, but receive half pay during that time. Here, it's important to note that these requests, the employee can't unreasonably refuse them. There's not a lot of guidance on what unreasonable refusal would be for an employee, but it might include things like the changing days doesn't fit in with the employee because of caring arrangements, or they can't work in the evenings for some other reason. So there's a number of different factors that might come in there, but they can't unreasonably refuse.
Joe, we've had a question come through, which we may have already dealt with. But if they are award free, can we change their salary re JobKeeper?
That's such a good question. So at the moment, if you are looking to use the stand down directions, as we said earlier, you can't change their hourly rate of pay. So there's this question mark around the idea of, can you go through just an agreement process, which is separate from the JobKeeper directions under the Fair Work Act, that enables you as the employer to agree with the employee to reduce their salary and therefore effectively their hourly rate. There is, some suggestions that that would be kind of avoiding the scheme of the legislation. Having said that, that inability to reduce hourly rate only applies when you're standing down. So if you're keeping them on the same hours, there might be some scope to do it and not breach the legislation. So
definitely a grey area.
Definitely a grey area, and one that I think everyone needs to get individual advice on. Let's have a look. But, at the end of the day, you've still got that stand down right that already existed in the Fair Work Act, and you do have the ability to make agreements with employees. The big risk here is that sometimes where you are making agreements, it might be more of a forced arrangement and there might be some coercion involved. And there's a risk that the action that you take will be deemed to be what's known as adverse action, where you're breaching someone's workplace rights by encouraging them, coercing them into a scheme that is putting them in a worse off situation. All right. I think that kind of covers the directions and the requests. So we might scroll back through and see what questions we've got.
Just had one come through. If I've paid out all my employees' holiday pay owing, do I then only start the $1,500 per fortnight after running out of holiday hours? After the holiday hours have run out?
So this gets into the fact that a lot of employers have been agreeing with their employees to take annual leave whilst this transition period has been in place and there hasn't been enough work for them to do. And it's in many cases the decision between terminating their employment or just keeping them on whilst they use their annual leave. If you've been using annual leave and the value of it is still over $1,500 per fortnight, then you can still be claiming the subsidy for that period.
Yeah. As far as the wage condition is concerned, it does not matter how that's paid as long as they're getting $1,500 per fortnight.
Yeah. So if they've been using their holiday pay, but it's been under the $1,500, you would just top it up. And then, which you are, as we said, still allowed to do in April. And then you would be able to claim that $1,500 subsidy for those April fortnights as well. Yes, Dan?
Yep. Agree with that.
Yep. Okay. And there is nothing to stop you, as we just said, from requesting an employee to take annual leave whilst you're receiving that $1,500 subsidy for a fortnight. So you might have stood them down, but you might actually turn around to them and say, I know you're stood down, but I would actually like you to take your $1,500. Obviously, there's benefit to the employer in doing that, because that means that you're reducing your annual leave liabilities. And you're also having that $1,500 worth of it per fortnight paid for effectively by the government. Employees, on the other hand, may think that's not fair. This is my annual leave and I don't want to take it. But as I just mentioned, if you're making a request to the employees to take their annual leave, then they can't unreasonably refuse to take that annual leave.
We've had Ashley send through a question. Could an employer change their pay frequency from monthly to every 2 months to help with cash flow? The rules require the payments to be made fortnightly, but there is provisions in there that if your ordinary period of pay is not a fortnight, then you can continue doing that and they just average those amounts over the relevant fortnights. I would be concerned, though, if you're changing from something you've done previously, so monthly to 2 monthly, especially if it's 2 monthly in arrears, that could fall within the integrity rules. So I'd be very careful before you decided to do something like that.
And also, most awards will have arrangements if it is an award-covered employee. Most award-covered employees, there is something in the award that specifies what payment frequencies you have to comply with. So, even if you had some non-award covered staff who you could perhaps make that agreement with, you wouldn't be able to do it for your whole workforce.
If someone's been on unpaid leave for, I guess, whatever reason, are they still allowed to receive the $1,500? Yes, as long as they're still employed and you're still meeting the wage condition, then yes, they can still get the subsidy.
Yes, absolutely.
And if you normally paid normal part-time salary under $1,500, do you get a partial payment, or were we meant to suddenly pay the part-time worker more for the period? We have one casual that gets $550 per week. How does this work? So the answer is yes. If they're getting paid less than $1,500, you need to top up to $1,500 per fortnight. You can't just choose to pay the $100 per week. If you pay that, you're putting in breach of the rules, and you won't get any subsidy from the government.
Yeah. So, and that's the thing about, one in, all in too, isn't it? Because if you've got a worker who's only earning $150 a week and you have to top them up to $750 a week to meet that, $1,500 fortnight, that's a substantial extra amount of money that you, the employer, are having to find to do the top up before you get the subsidy reimbursement.
So, hopefully we'll get clarity on that one in, all in provision soon.
Absolutely. This has also come up with some people saying that as employers, they feel that it's unfair that some of their employees are, only earning $150 a week normally, and all of a sudden it's going to bump up to $750. Whereas other workers who are still working and they're, they already normally earn $750 and they're going to be working those hours, they don't actually see any benefit.
So I guess I can see sort of a couple of rationales for why they've done that. One is just for simplicity. Everyone gets $1,500 regardless of what they're earning. And the other case is, well, you might have a part-time employee that's earning $300 a week, but across 3 different employers. So the rules for simplicity just say you claim through one employer, and so therefore they're not sure how much you're getting from other employers. So they've just made it $1,500 per fortnight for each employee. So I think it's mainly around simplicity that they've done that.
Absolutely. Yeah. And, you may feel that it's a little bit unfair, but it's just the way it is, unfortunately. A question that came in quite early on was, if an employee's been stood down, and let's say that was from last week, do you then need to back pay them from the 8th of April being the stood down date until payments start in May? Again, the answer is yes. If you want to receive the subsidy, then you need to be paying in the fortnight, or at least in April, need to be paying in April for the 2 fortnights in April to claim the subsidy.
We should. You don't have to claim it. You can decide we don't want to claim it right from the start and claim partway through. That's entirely fine. But once you do join the scheme, then you will have to be paying the $1,500 per fortnight from that period of time.
That's a really good important point, and we'll probably end there, which is the fact that you might not want to join the scheme right now. Maybe you want to wait and see how things go. Yes, that means you lose the opportunity to claim the $1,500 per employee for the month of April or for the period of time before you enroll yourself. But you might feel more confident in your eligibility. You might have the cash ready to go. You might have things sorted out, and you might be in a position to claim from May or from June or from July or any time through to the end of September.
We'll just deal with one more question that just came through. Students who are receiving $1,500 a fortnight instead of the usual 150, will that mess up the youth allowance? Yes, it will. It is factored into other government benefits. So if you've been receiving JobKeeper or any other government benefits, this will be reportable income you need to report to Centrelink.
Yeah, absolutely.
And
there's a payroll question. On the pay slips, do we classify the amount as allowances exempt from tax withholding and super, or allowances subject to tax withholding and super?
So if we're talking about the top up amount, it would be taxable. So it is subject to pay-as-you-go withholding, but it should be exempt from super for the top up component.
Yeah. So, and that's the confusing bit, isn't it? Like all of it, the 1,500 is all tax withholding, right? Whether the person is working or not, it's all tax withholding. It's just a question of whether or not super is paid on all of it or some of it.
Yeah, that's right.
Yeah. So there might be two entries.
Yeah. And I'd say if you're in your payroll system, this top up component that's in addition to what they're normally getting paid should be recorded as a separate line item.
Yeah. Okay. Awesome. So Dan and I, as I said, we're trying to put together a quiz. Hopefully we'll get onto that. We're both creating some different summaries of things. So if you're interested in receiving that, then, drop us a comment in the live below, or just a thumbs up. And when we get around to producing the written versions of things, then we can share them with you. And as I said at the beginning, if you're watching the replay, feel free to tag Dan or I with any other questions that you might have that have arisen from this. Otherwise, we hope you found that valuable. And if there's something that you would like particularly answered, we can perhaps jump on another live and do some more Q&A time. So thanks very much.
Thank you, everyone.